మనం మళ్ళీ వీడియో చెప్పేటప్పుడు వస్తే వర్కౌట్
फिर आप रहना ना यार.
ఇప్పుడు మనం సైడ్కి నిలబడి వచ్చేయం కాదు అంటే ఆమె చెప్పిన తర్వాత
Hello everyone, my name is Juveria and these are my group members Ravi and Raju. Today our topic for our case study is Great China Metal Industry Co Limited versus Malaysian International Shipping Corporation. Now I'm going to talk about the background of the dispute. In the case Great China Metal Industry Co Limited versus Malaysian International Shipping Corporation, the trial took place in the Admiralty Division of the Supreme Court of New South Wales before Judge Karata. In this particular case, the contract of carriage was subject to the Hague Rules and enacted in the Australian Sea Carriage of Goods Act 1924. In 1989, the vessel named MV Bunga Seroja sailed from Sydney carrying a cargo of 40 cases of aluminium can body stocked in coils packed in 10 containers. The voyage was consigned from Sydney to Keeling, Taiwan. The respondent issued a bill of lading dated 5 October 1989, confirming receipt of the goods in that they are in good order and condition. However, while the vessel was transiting the Great Australian Bight, it encountered heavy weather that had been forecasted before departing from the port. Some of the goods were damaged due to the heavy weather. So according to the Hague Rules, neither the ship nor the carrier was to be held responsible for any loss or damage arise from the perils, accident or danger of sea or other navigable water. Now I would like to call Ravi to continue with this case. Thank you, Ravi.
Thanks. So here I present some of the facts of the case. So let's start with Great China Metal Industries Co Limited. The Great China Metal Industries contacted Malaysian International Shipping Corporation for the consignment of carrying a cargo of aluminium foils from Sydney to Keelung, Taiwan through Melbourne, Burnie and Fremantle. There was also evidence of carriage contract made, each incorporated to the Hague Rules. Then the carrier was stowed the cargo from Burnie to Fremantle. There was a series of violent storms while transiting the Great Australian Bight, and dock containers were swept overload and the cargo was damaged. Captain Singh confirmed that the weather was worse with tremendous winds and was risky to anyone for checking the docks. The ship was structurally damaged during the storms. Therefore, the judge ruled that the damage to the goods arose from perils of sea. But as the weather was reasonably foreseeable and was actually foreseen by carrier, based on which the contractor argued that the carrier cannot depend on the perils of sea and should not be exempted from the liability of the damage of the cargo. Next will be explained by Raju.
Thank you, Ravi. Myself, Raju, I am going to discuss legal issues presented by the court. The central issue presented before the court was whether the damage to the coils was result of the perils of the sea or the carrier's negligence or breach of the Hague Rules. Indeed, the judge held that the pounding of the ship by the heavy weather caused the damage and this was a peril of the sea. Another legal issue presented was that the ship masters should have postponed the journey or diverted the route to avoid the weather which was forecasted by the team. And the individual parties based primarily upon the Article 3, Rule 2 of the Hague Rules, which states that the subject to the provisions of Article 4, the carrier shall properly and carefully loaded, handled and slowly carried, keep care for undischarge of the goods carried. And he argued about the Hague Rules are not applicable to the Malaysian International Shipping Corporation. On the other hand, the respondent respond to the appellant's contention relied upon two of the exemptions. The court held that there was no neglect or default of the ship's masters or other servants. When it comes to the issue of carrier breaching, the Article 3, Rule 1 or 2, the court refused the applicant's claim that due to negligence. The judge held that the ship was fit for voyage when it left the port. Thank you. And the next part will continue by Ravi.
So I'll be discussing with the individual parties' arguments, starting with Great China Metal Industries Co Limited. The appellant's case was based primarily upon the Article 3, Rule 2 of the Hague Rules, which states that subject to provisions of Article 4, the carrier should properly load, handle, stow, carry, keep case for and discharge the goods carried. He further argued perils of sea are not applicable if damage emerged from sea. The appellant contended failed to impose a route or discharge dates upon the ship owners. Master should have either postponed the vessel's departure or used another course to avoid the risk of heavy weather that was already forecasted. Therefore, in this case, the appellant pleaded that the respondent failed to meet its responsibility as stated in the Hague Rules, Article 3, Rule 1, to exercise before and at the commencement of the voyage. Also, it accused the respondent of failing to properly and carefully load, handle, stow, carry, keep, care for goods as per Article 3, Rule 2 of the Hague Rules. The next one, coming to the other side of the argument of Malaysian International Shipping Corporation, which states as the respondent's response to appellant's containers relied upon two of the exemptions contained in Article 4, Rule 2 of the Hague Rules, which states that neither carrier nor the ship shall be responsible for the loss or damage arising or resulting from act. Based on these, the respondent pleaded that it was not responsible for any loss or damage to the goods arising from the perils of sea. The respondent was right to the base of the arguments on Hague Rules. During the ruling, the judge could have held the respondent responsible if it was proved that he had breached obligation to take care of the cargo. The rest of the part will be concluded by Raju.
Thank you. Now I am going to discuss about the tribunal decision. Judge Carruthers read the court decision on this case. While making decision on this case, the judge considered if the carrier had fulfilled his obligation under Article 3, Rule 1 of Hague Rules, which states that the carrier shall be bound before and at the beginning of the voyage to exercise due negligence to make the ship seaworthy, properly man, equip and supply the ship, and make the holds, refrigerating and cool chambers and all other parts of the ship in which goods are carried fit and safe for reception. Given that a trial court had accepted that the heavy weather encountered was reasonably foreseeable and was actually forecasted, the trial judge used the evidence provided on how the shipper had packed the containers to rule that the respondent had fully fulfilled his obligations of due in accordance with Article 2, Rule 1 of Hague Rules. Based on the evidence, the judge revealed that the respondent had properly, carefully loaded, handled, and stowed, carried, kept. The judge found no act of negligence is found. Heavy weather happened at Great Australian Bight, caused coils within the containers. As per the court decision, the rulings of Admiralty Division of Supreme Court of NSW were challenged on appeal to the Court of Appeal of NSW. This court dismissed appeal unanimously and case was dismissed. Now the next conclusion will be given by the
Thank you,
jury.
Raju. Finally, I'm going to talk about the significance of the case in international law. In the case of Great China Metal Industries Co. Limited versus Malaysian International Law, the concept of the peril of the sea has been the basis of the ruling case regarding maritime. The Hague Rules outlines different provision about the obligation of the carrier and all that carriage contract entails. The judge's decision was also based on the peril of the sea. Therefore, the common law of the peril of the sea implies that ship owner is liable for any loss or damage that takes place during the voyage. Based on this, the common law would argue that when the ship departs and it has proven that it was fit, then encounter with the ordinary peril is expected, and the ship master should be ready to properly handle such situation. Thank you for giving this opportunity to present ourselves in this video. Thank you, Jonathan, and thank you,
Thanks.
Thank you.
Thanks.